Welcome to today's program titled Heat Illness in the Workplace, How to Protect Your Company from Liability and OSHA Enforcement. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials along with the CLE attendance form will be distributed to attendees in the days following the webinar.
All right, good afternoon, everyone. My name is Adam Young. Thank you for joining us for our presentation today on heat illness in the workplace. I'm a partner in our Chicago office and am lucky enough to be joined by Mr. Joyce, Mr. Leese, and Ms. Marati from our Seattle, Chicago, and San Francisco offices, respectively. Our workplace safety group has members in 6 offices around the United States, and we're one of the largest workplace safety teams at any firm in the U.S. If we go on to the next slide. We're here to talk about heat illness, which is a very hot issue. We've got a national emphasis program. We've got a draft OSHA standard that's out there. We're going to explain to you the bases of heat illness and talk about liabilities that come from OSHA and then come from other related employment statutes. And we're also going to talk about some state regulations related to heat illness, as well as, well, how do employers address this? Are you doing enough? And what more can you do to reduce your liabilities and the chance that someone gets heat illness at your workplace? If you have any questions at any time throughout this presentation, please feel free to send us a chat. We'll try to get those addressed. We do have a lot of information, so we'll be moving fairly quickly. But these slides will be available to you. The webinar will be posted, the slides will be available, and there will be a CLE code that's provided by the last or second to last speaker. If we go on to the next slide, please. All right, so OSHA, federal OSHA regulates employees in 20 private employers in 29 states, and every state plan of the 21 remaining states is required to have regulations at least as protective of the employees as federal OSHA. Federal OSHA currently regulates heat illness through its general duty clause, meaning it's pour over requirement that employers provide a workplace free from any recognized hazard. But they've also put together a new set of regulations, a heat illness standard. It's in the drafting process. We haven't seen the final product. They've warned us that it could take 5 years, maybe up to 10, to get it finalized and out the door. But we understand that it is in process, and we're going to update you as it comes out. We attended a meeting with Doug Parker, the head of federal OSHA, 8 weeks ago in March, and he said that heat illness is the #2 priority for the agency this year after COVID. So it's going to be their #2 enforcement priority. They're putting together regulations to address it. They look at the world through their own perspective, and they see heat illness as such an important safety issue because of climate change, right? Climate change is increasing the temperatures out there, increasing the humidity levels, and increasing the possibilities of heat-related hazards, particularly at night where it's much hotter than it has been in past years. They also see it as a big challenge from a DEI perspective in that minority and vulnerable populations are disproportionately exposed to heat illness and heat-related fatalities. So it's the reason they're going for that heat illness standard. If we go to the next page, please. 2 months ago, Vice President Harris announced a new national emphasis program for heat illness. And OSHA can do inspections of employers on several bases. They have to have probable cause to come to your work site and do an inspection. They can either do a complaint-based inspection, an injury reporting-based inspection, or a programmed inspection. And these programs, like this national emphasis program, allows OSHA to generate a list of high-hazard industries and a list of potential work sites, and then to go out and do these inspections. So the emphasis program for heat illness is new. It's going to be in effect for at least the next 6 months. They're going to be out this summer doing these programmed inspections at high hazard workplaces, and they provided a matrix for what constitutes a high hazard workplace. And it's judged by NAICS code or the NICS codes. Construction's on the list, a lot of manufacturing's on the list, warehousing is on the list, nursing homes is surprisingly on the list. So they're going to be out there doing these heat illness inspections. Possibly more importantly than that is this emphasis program instructs the compliance officers, if they're doing inspections on something else, that they can expand those inspections to heat, where hot conditions are observed, employees are working outside, employees are working inside, but they have high metabolic heat because they're all over the warehouse. They are working near a furnace or some other source of heat. So we're going to see a lot more inspections that expand into the heat area. I can say, at least in California, most of the inspections I've been involved with, OSHA is asking for that heat program, and they're trying to expand the scope into heat illness. And Alana will provide more detail on what's going on out there. And then finally, it instructs compliance officers to look for employees who are exposed to high temperatures and make sure you understand their training and what they're doing to acclimatize. And then the big three for dealing with heat are always going to be water, rest, shade. So that's the three things they're instructed to look for in that regard. If you go to the next slide, please. All right, so we'll back up. Let's talk about what is heat illness. Why is it important? Let's go on to the next slide. There's 5 different kinds of heat-related illnesses, and the most serious being heat stroke and least serious being heat rash at the bottom. The CDC has a listing and an instruction that employers could look at if you want to learn about heat illness and understand the bases for it. For each of those 5 types, heat rash, we're talking about red clumps or blisters on the skin. Sunburn, it becomes more painful. It's red and warm skin. Heat cramps is where you get the heavy sweating and the muscle pain starting. Heat exhaustion, we're still sweating. We have cold, pale, clammy skin. You start getting the tiredness and weakness. And heat stroke, we're talking about 103-degree body temperatures, nausea, confusion, passing out. If a heat stroke is going on, those types of symptoms, the CDC recommends calling 911 right away. Giving the person water, it's too late for that. Getting the person in a cooler space may be helpful in the short term, but the person is at very high risk of serious injury or death. Unfortunately, we've defended several heat-related death cases, and reading those medical examiner reports is just absolutely heartbreaking. The individual's internal organs liquefy, their blood turns into like a thick solid, and it's an absolutely horrendous illness that can occur with regard to people. So to the extent this is becoming more of an issue, nationally, more employers are going to have to be aware of these terrible illnesses. If we go to the next slide, please. And there's different factors in whether or not there is a heat-related hazard in the workplace. Now, we talked about the OSHA General Duty Clause. It requires employers to address a recognized hazard. And whether there's that recognized hazard isn't just the air temperature. It's also whether the air is moving. Is the person inside or in a utility vault, or are they outside standing by the highway, as Mark's going to talk about? There's different air movement in those two settings. Humidity, obviously very important. Whether the person is hydrating, right, because they're going to produce sweat, and that's how they're going to cool off. And then finally, metabolic heat. So it's not really a complicated concept. If the person is burning a lot of calories and engaging in strenuous physical activity, they're more likely to have heat that they're producing themselves and contributing to that heat illness. Heat index is something that employers are required to keep awareness of and tracking as to what the proposed weather is going to be for their job hazard analyses. And heat index is temperature, but it's also humidity and solar radiation as well. So if there's clouds blocking out the sun, or if the sun's beaming down on someone working on a roof, it's a very different situation. If we go to the next slide, please. So going to whether there's a heat hazard, the main way to test for that would be the wet bulb thermometer. That's kind of the gold standard, because that's going to tell not just the heat and the humidity, but how easy it is for the water to evaporate on someone's skin. If we go on to the next slide, please. All right, so this is a chart that goes through heat indexes and where we have the very high to extreme risk levels. That's going to be greater than 115 degrees, but even at 91 to 103 degrees, we're talking about a moderate heat index risk. And most of our clients are putting together policies and programs that have corresponding precautions and protocols to each of these risk levels. Let's go on to the next slide, please. All right, so this is the Farmer's Almanac predictions for this summer, and they are using a lot of synonyms for the word hot, right? It's going to be very warm, sizzling, broiling, hot and humid across the United States. So, yeah, it just got hot in the Midwest this week. It's going to be a hot summer. We recommend, if you don't have a heat program in place, now is the time. And this is a very well-timed webinar in terms of that hazard. But heat illness can also exist indoors, right? We talked about the types of heat, and we have even seen heat illness cases in Chicago in the winter, where employees are working in freezers. They're wearing very heavy clothing. They're then outside of that freezer in the heavy clothing and exposed to heat illness in that form. So let's go on to the next slide, please. Heat illness is very prevalent. The number of fatalities in 2019 is 43, is what OSHA gave, and they think that number is greatly underreported. There's a lot of reasons that someone could pass out from things like heart disease or hypertension, and maybe that heat is contributing to more deaths than it's being reported. We're seeing a workforce that's been changing over the last 20 years, a workforce that's suffering from more heart diseases, more hypertension, more diabetes, and those people are at greater risks of heat-related illness. That's as the planet is, slowly warming. OSHA's concerns with regard to vulnerable populations and minority employees are well-founded in the data. The data shows Hispanic workers are greatly disproportionately affected by heat illness, as are agricultural workers. So there's reasons, supporting their concerns and where they're coming from with regard to that new heat illness OSHA standard. Let's go to the next slide. We also want to keep in mind there is still this COVID pandemic that's ongoing, and it has direct impacts and effects on heat illness. COVID-19, the limited research shows that having long COVID is a great increased risk factor for developing heat illness. Individuals have trouble breathing, they're developing more metabolic heat, and they're more likely to suffer from heat illness and heat-related injuries. To the extent, some of our clients are still seeing widespread masking on a voluntary basis. To the extent people are wearing masks, obviously they're going to be more likely. It's like wearing a scarf over your mouth, right? You're more likely to be suffering from heat in that regard. And there's the overlap of COVID. There's also the overlap of drugs and alcohol, right? We have a very low unemployment rate. A lot of people are returning to work that might not have otherwise been working in those fields. And we're seeing a lot of heat-related illnesses and heat-related incidents overlapping with individuals who are violating drug and alcohol policies. And I can say, at least anecdotally, in the last few years, the heat illness inspections I've defended, at least half of them, it's turned out the individual died while impaired by drugs or from a methamphetamine overdose, where it got the person's body temperature very high in and of itself and looked a lot like heat illness until we got the medical examiner's report. So I'm going to turn things over to Mark, who's going to talk to us about legal liabilities. Thank you.
Thank you, Adam. Pleasure to be here. So now we're going to talk about the downside, if you will. We're encouraging everyone to have a heat illness program, but if you don't, these are some of the things you need to be concerned about. I think we all know what the general duty clause is. It's not a regulation. It says that there's a recognized hazard likely to cause serious injury or death, then an employer has to take feasible steps. Obviously, not all heat is going to cause serious injury or death, and that's why in your program, as where speakers are going to point out, you need to monitor the heat to see at what point in time it does become a hazard, and some of these regulations will define that. And then we start to have to take precautions for our employees based upon our plan. Now, there's also some feed-offs on that. As you probably know, and you'll hear a little more about this, the progression from a lower level heat hazard to one that could cause serious injury or death can be very rapid. And OSHA has regulations, and I'm sure you're aware of that requires you to have first aid. If you don't have first aid capability inside, in other words, the person has got heat exhaustion or heat stroke, and you know what to do about it, you can rely upon the outside responders, but they have to be able to get there in 3 to 5 minutes or be 3 to 5 miles away. There's also requirements to have potable, drinkable water at your work site. So keep those in mind. If you do get a general duty class citation, and it's got to be classified as serious, starts out at that. Those are $14,000 in change. If they decide you don't have a program and you deliberately ignored it, then it could be willful. Those could be up to 10 times that amount. Let's talk a little bit about whistleblower protection. As we all know, employees have a right to make complaints about safety and health if they think that they're at risk. We've seen a lot of those. In fact, we've seen some heat illness related ones. And if they make a complaint, they don't have to refer to OSHA. They don't have to say whistleblower. They can say, I don't feel safe, and this is why. And then if we take adverse action against them and our action is not justified, then we could face 11C liability. So what are we seeing? Employees potentially refusing to work in high heat conditions because they don't believe they're safe. What do? You sit down with them and you convince them, I have a written program, I've trained you, we have water, we have ice, we have Gatorade, we have a buddy system, the supervisors are monitoring you, we have shade, we have air conditioning. Now, with that, we believe you're fully protected, you should go back to work. If they still refuse, don't terminate them, consider suspending them, and it puts the ball back in their court because you acted reasonably. So there is potential for whistleblower complaints. We've had a number of those. We can help you respond to those. Adam's already pointed out a little bit about the number of statistics that we have relating to citations. By the way, if you've ever gotten a hazard alert letter, they call them HALs. It has nothing to do with that movie about 2001. If you get a hazard alert letter, you should respond back to that and tell OSHA what you're doing so that they don't decide to come out and potentially conduct another inspection. We tried a long case. Patrick and I were involved in this, the Aldridge Electric case, nationwide electrical company, 4 years ago. And it involved an employee who came back to work. He'd been off of work for 5 months. He was a laborer, came to work on putting a new electrical lines in the Dan Ryan Expressway down the median strip. The gentleman was 5'9", 290 pounds. So right away you can see that there's some issues there. Comes to work, gets his orientation, which includes heat illness training, before he even gets in the van to go out to the work site. He gets more training when he goes out to the work site about heat illness. And by the way, he brings his own water jug out with him. So he goes to work, everybody's glad to see him, and they put him on light duty. They don't want to start him out on the heaviest duty. They give him light duty. And he's fine. It's 72 degrees. There's a light rain. Everything is fine. Noontime, he sits down with his buddies in an ATV, has his lunch, drinks from his water bottle. Everything's fine. About 1:30 in the afternoon, one of his buddies tells the supervisor he seems to be having trouble moving around. Supervisor goes and talks to him and says, why don't you go over and get in that air-conditioned vehicle, cool down a little bit. We've got plenty of workers here today. Let's take care. 2 minutes after that, about 10 minutes later, he's seen getting ready to walk off the site. The supervisor says, hey, I thought I told you to stay in the air conditioning. He says, I can't feel my legs. So supervisor who's trained says, aha, we got cramps, one of the lower level of heat-related illnesses. Says, get in this ATV. I'm going to take you up to a cooling van. On the way there, he starts to rapidly degenerate. By the time they get to the off-ramp, or the ramp to get out of the CTA, and by the way, it's only 82 degrees, slightly above 82 degrees at this point in time. He's now becoming incoherent. He has to be basically carried or helped to get up the ramp. They put him on the floor. They cover him with ice. They put a towel over his forehead with water. The Chicago Fire Department shows up. They take him to a hospital. 2 days later, he passes away at 108 degrees. Internal body temperature is actually a little higher than that. And as Adam pointed out, there was no opportunity for an autopsy. So we went to trial. The company said, we're not going to take a citation. We think we're right. We went to trial for 18 days. We got a 51-page decision from the judge. The judge said, it's unfortunate that somebody passed away, but there is no legal liability here because you did everything that you needed to be done. You had a written program, you trained people, you had all the water, the Gatorade, you tried to put them in air conditioning, you got him out of there as soon as possible. You had a buddy system, and unfortunately, he passed. No liability. So that's, if you ever run into this, that's the best case scenario that you're going to ever get in one of these situations. But it also points out the rapid deterioration of an employee when they're doing this, and the importance of having somebody there with first aid knowledge, either your own folks or EMTs that you can get there in a very short period of time. OSHA's tried other cases. They lost the Sturgill roofing case, but they did win a big case against the United Postal Service, basically on the point of view that some of the letter operators were told to continue making their deliveries, and they were also using vehicles where the air conditioning wasn't working. Employees were complaining about that, and employees suffered injuries as a result of that. Let's go to the next slide, please. Okay, so what are some of the other legal liabilities? These have nothing to do with OSHA per se. We know under the ADA, people with certain types of disabilities. In the case of the Aldridge case, that gentleman was morbidly obese. He was more than twice the recommended body weight. But we can have other types of disabilities. There's a couple of them down there: diabetes, cardiovascular disease. We can also have employees experience seizures as a result of exposure to that. Multiple sclerosis can cause that. So employees who have disabilities are allowed to work as long as they are able to perform the essential functions of the job. Now, what I've already talked about an 11C complaint, you may have an employee come up to you and he doesn't have to use the word ADA. He doesn't have to say anything. He may say, I'm really being affected by the heat today, and I think you need to give me some type of an accommodation or some type of assistance. That could be argued to be a request for an accommodation under the ADA. And you have to engage, those of you who are on here who are the HR folks, you know you have to have an interactive process, and you sit down and ask the employee, okay, what assistance or accommodation do you need? What documentation can you provide me regarding that, so I can decide whether or not I can accommodate you? Because some people may, frankly, if you're outside and you're in construction all the time and they have a very severe case, it could rise to the level under the ADA of a direct threat. A direct threat means if they continue working that job and they can't be accommodated, it could result in serious injury or death to them or to other employees who they're working with, particularly if they're operating any type of machinery or equipment. So you have to have that process. Ask the employee to provide you with information so that you can make that particular determination. We've done a few webinars on this heat illness recently, and one of the issues is duty to hire. And there's nothing that prevents you if you have high heat type jobs, furnaces, production where there's high heat, steam, things like that. Make sure that your job description shows that as a essential function of the job during the hiring process. And then you, if you offer an employee a job and you send them out to determine whether or not they can perform the essential functions of the job in those conditions, then and they're not qualified, you can take back the offer of employment. Same thing goes if you've got somebody. Metabolic heat can be generated by wearing a respirator, as Adam has pointed out, or self-contained breathing apparatus. If an employee does get ill and they've worked for you sufficient time, they may be entitled to unpaid leave under the Family Medical Leave Act, up to 12 weeks of unpaid leave during that particular period of time. By the way, some of our clients are using thermal scanners for employees who work around furnaces or in extremely hot areas to determine whether or not the employee may be getting to a temperature level that they need to be rotated in the job to make sure that they're not overcome by heat. Let's go to the next slide. Next slide. This is the Bermuda Triangle. Okay, actually, I guess it's the three Bermuda circles. Anyway, we've already talked about the ADA, but when you have somebody who's injured or is requesting an accommodation, you cannot have tunnel vision. You have to look at all three of these. How do they play together? And obviously, you can be an action brought against you if you terminate some employee because they had a heat-related illness. and they claim workers' compensation benefits and they're terminated. If an employee is entitled to FMLA, we need to give them their FMLA rights. If they're not entitled to FMLA, they still may be entitled to unpaid leave under the ADA as an accommodation. So that's one of the reasons why you want to say, what do you need? What assistance do you need? Please provide that information to me. Let's go to the last slide, next slide, excuse me. This is workers' compensation. And if an employee, as you all know, has an injury or an illness that arises out of in the course of employment, that employee is entitled to workers' comp benefits, based on the schedule that is in the Work Comp Act. On bullet point number 2, you take your employee as you find them. So if they have a pre-existing condition that's aggravated or accelerated, you bought the whole package. That's why it's important to have pre-employment physicals if you think it's necessary based upon the essential functions of the job. And if an employee files a work comp claim, a lot of employers in the old days used to say, you file a comp claim, you're done. We'll pay you off on the side. We'll give you some cash, but you're not going to file a comp claim. That's outlawed in every state now. You simply can't do that. And by the way, in certain states, if OSHA can prove or if it's proven that the employee's injury is due to a violation of a safety or health regulation, there is an add-on penalty that can be up to 50% of the employee's compensation. Ohio is a state like that, and other states. So those are your heat illness liabilities. I'm going to turn the slides over now to our next presenter.
Alana, you're muted.
You're muted, Alana.
Thanks, guys. So several of the state plans have their own unique heat illness standards, and we'll take you through some of the main ones. First of all, California, they have an outdoor heat standard that applies to all employees who work outdoors. There's also a proposed indoor heat standard, so look for that coming soon. Colorado has one. It applies to agriculture, became effective this month. Maryland, we're expecting to see one later this year. Maryland OSHA has to adopt it by October. Nevada, there's a proposed rule. Oregon, we have a rule that just became effective, a permanent rule. And then Washington has a temporary rule right now that applies during certain times of the year, and looking at proposed changes to that coming up in the near term. Next slide. So California started as an emergency standard, and it's been permanent since 2006. So it's been in play for quite some time now. As I mentioned, it applies to all outdoor places of employment, and OSHA takes a broad view of outdoor. So you're basically thinking of any place that's not indoors, doesn't have a roof, and 4 walls. That could even include, being in a vehicle. OSHA does right now cite employers for indoor heat hazards as well, so that's important to keep in mind. They don't have an indoor heat standard. There is one proposed. It's been in the rulemaking process for years. At some point, we expect that to become an actual regulation. But in the interim, OSHA uses their IIPP standard to cite employers for indoor heat hazards. IIPP is, you can essentially think of it as like California's version of the general duty clause. So they use that to cite when they don't have a specific standard. You can go to the next slide. So the primary requirements to comply with California's standard. First of all, you have to have a written heat illness prevention program. And again, that's going to apply if you have any employees who work outdoors and are exposed to potential heat hazards. You have to train employees and supervisors about heat illness prevention. You're going to have emergency response procedures. And so that's going to be, responding to employees commensurate with the symptoms that they're displaying. You have to acclimatize employees. So if they are new to a job, that's going to mean intensive supervision for the first 14 days to make sure that they're adjusting to the outdoor work. And then there are water and shade requirements. The key here is that there are temperature triggers where certain things become required in California, but water and shade, those are required regardless of temperature. So if you have employees working outside, you have to make sure that they have enough water so they can drink at least 1 quart per hour. And then same with shade. You're going to have shade available regardless of the temperature. What happens if you get to 80 degrees or higher is that shade not only has to be available, but it has to be present and nearby. But just keep in mind that regardless of temperature, there's always going to have to be the potential availability of shade. Something also key about California to keep in mind is that the temperature triggers are air temperature, not heat index. And you'll see as we go through the other states, some states use a heat index. And so that can make it challenging, especially for employers with operations in multiple states. You have to be very mindful of what triggers requirements under these unique state standards. If the temperature is 80 degrees or higher in California, you also need to encourage workers to take preventative cool down rests if they feel the need. And then something you have to keep in mind in California too is risks to employees who are driving in vehicles without air conditioning. This is sort of a hot topic in California. We have seen many citations that employers will receive because they have employees in cars without air conditioning. If it's not a requirement that you have air conditioned vehicles, but you do get into the risks of potential liability because if employees can't easily access an air conditioned facility like a convenience store or a customer site, then you can end up with citations. Next slide. You also have high heat procedures in California. So that's when you have temperatures equal or exceeding 95 degrees Fahrenheit. That's only going to apply in certain industries, agriculture, construction, landscaping, oil and gas extraction. It also applies to employees who are transporting heavy materials. So think like agricultural equipment, things of that sort. And again, those high heat procedures will apply to all of these industries. The exception is that if you have someone transporting heavy materials, but they do not have to load or unload the vehicle, then the high heat procedures will not apply to them. And what are these high heat procedures? It's essentially like enhanced supervision of the employees and making sure that you have easy communication to those employees. So, making sure they have a cell phone at all times so that they can call if they're experiencing symptoms. You are actively encouraging them every day to drink water, monitoring them, etc. Next slide.
All right. I think that's me. Thanks, Alana. As Alana mentioned, one of the issues that a lot of nationwide employers or even regional employers are going to be dealing with is the difference in not only all of these state-specific requirements that are out there or coming down the road, which Alana laid out at the beginning there, but also the National Emphasis Program for federal OSHA and then any future federal OSHA regulations that may come down the line. And what we often will recommend to clients is, well, if you have nationwide operations and that includes California, California is usually the strictest. So it's often best to take what California does, and that should get you at least 90% of the way there for the rest of the country. But as you'll see in these Oregon, and then I'm going to go into Washington after that, that might not necessarily work in this case because the various state plans in Oregon and Washington each have their own little nuances that may be difficult to implement or not necessary to implement in other locations. Another thing that Alana mentioned, which is you'll see here between Oregon and Washington, is the threshold being either heat index or the actual air temperature, and then any other calculations that may be required to adjust those temperatures for certain activities. So that's all to keep in mind as we go through the next couple of slides here. In Oregon, the state issued a temporary rule, emergency temporary rule in July of last year. And that was in response to the heat wave that if you live or lived or have been to the Pacific Northwest was very much out of character. I think Portland International Airport was something like 116 degrees or 119 degrees in June of 2021. Seattle Tacoma, it was in the low 100s, 108, 109, 110, which is just not characteristic for those areas. And the difference again in Washington and in Oregon is that homes where people go home after work and rest, a lot of homes are not air conditioned. So what was happening is workers were at work and it was hot, and then they were back at home and it was hot, and there was no chance for them to have that cool down period to reduce the risks associated with heat illness. And unfortunately, that resulted in a number of fatalities in the summer of 2021. I'm just going to go through the temporary rule here really quickly because there's now a permanent rule that was just issued on Monday for Oregon. So the temporary one had heat index thresholds at 80 degrees, where again had to be access to shade on site and cool drinking water. And Oregon actually defined what cool meant. It was anything under 77 degrees Fahrenheit for the water, and above freezing, obviously, because you can't drink the water when it's frozen. And then also providing training to individuals, both employees and to supervisors. 90 degrees heat index. Again, there was a communications plan similar to what Alana was talking about, where individuals had to have walkie-talkies, radios, cell phones on them so that there could be very quick communication between the employees and management, and then observation to ensure that folks were being observed for the signs and symptoms of heat illness that Adam described at the beginning. The companies were also required to have an emergency medical plan, which was how are you going to get people off site to the medical care that they need in a timely fashion, which could be different based on where you're physically located. And then also acclimatization, which is the concept of if someone comes onto the site and they are not used to working in the heat, either indoors or outdoors, slowly working them into being used to the heat, the body will eventually acclimatize. Next slide, please. So on Monday, Oregon OSHA helpfully released its permanent rule, which is going to be effective on June 15th. It has some differences from that temporary rule that was in place last summer. The heat illness prevention plan, which is kind of goes along with what we've been talking about broadly, and I'm going to talk about in more depth with respect to the federal rules, has to be in place, it has to be written, has to include a provision for actually actively monitoring the temperature outdoors. One of the various ways that Adam discussed was this wet bulb globe temperature, which is a device that's actually somewhat complicated. It takes folks a lot of time to learn how to use. There has to be a written acclimatization plan, so the employer has to sit down and think about how when new employees come on site, how they're going to get used to the heat. It could be a percentage of active work for the first couple of days, and then maybe some administrative work for the rest of the day. And then you gradually increase that as time goes on. And then again, there has to be supervisor and employee training. The supervisors have to have an updated level of training to ensure that they are aware of how to respond, what to do if someone is starting to show the signs and symptoms of heat illness, similar to the supervisor in the Aldridge case that Mark mentioned, who took action. Unfortunately, it wasn't quick enough, but they took action and did everything that they were supposed to do. With respect to the heat index thresholds, very similar to the temporary rule, access to shade. Now, it does not require artificial cooling, so it just has to be shade. You just have to be out of the sun, and you have to have enough space for the folks that are on site actually performing the work to be fully shaded out of the sun. Cool drinking water, again, the same thing, under 77 degrees, and this time they added in a quart, which is 32 ounces, have to be available per hour, and the employer must have that on site. They must provide that for the employee. Over 90 degrees, there's a lot of communication and observation again, having walkie-talkies, having cell phones and observation, and again, continuing to actively monitor the outdoor temperature. And this actually applies indoors as well, in situations where you may be in a factory or something like that that does not have artificial cooling, and the heat index indoors gets above these threshold temperatures. The last thing is a defined work rest schedule. And don't change the slide yet, but I'm going to address that more in the next slide. The exemptions for Oregon are where an employee is exposed less than 15 minutes per hour as part of their job duties. Maybe they're only outdoors for a short period of time. They generally work in an air-conditioned office, but have to go out onto the plant floor. They are not required to be covered. Heat generated from work processes like a foundry or something where there's artificial heat added into the interior, that is also not covered. But there are other requirements that are already in place in Oregon that have to be followed to make sure that folks are safe from heat issues. They're much less, they're very basic, but they are still there. Emergency operations, your EMTs, your firefighters, folks who are outdoors and responding to an emergency, or indoors, that they're not covered. And then also, this was added from the temporary rule, operations with artificial cooling that reduces temperature below 80 degrees. Next slide, please. So with respect to the work rest schedules, this is a bit of a dense slide here. I'm not going to really go through it in all that much detail, but the idea is based on the type of work that's being done, employers are going to be required to implement a schedule to have them off for a certain period of time at a certain temperature. So for example, if they're just doing light work, administrative work, walking around, picking up very light objects, if you get to 106 degrees, and that's the adjusted temperature, that's 45 minutes on, 15 minutes off, and then as you'll see, that increases. Moderate work, heavy work, heavy construction work, those numbers happen at a much lower temperature. The Oregon schedule includes adding 13 degrees for direct sunlight, adding 7 degrees for shade, that type of thing. So there's a lot to think about. And this is just one of the recommended ways to do this schedule. Next slide, please. All right, on to Washington. Washington has had a permanent rule in place since 2008. It's very basic. It really only applies above 89 degrees, and then unless you have these specific double woven clothing or chemical resistant suits, and it only applies outdoors between May 1st and September 30th. There has to be training, basic training. There has to be, similar to a California IIPP, Washington has the accident prevention program. You have to have a heat section in there. You have to encourage, but not require, employees to consume water. And employees are actually responsible for their own self-monitoring. And this is also folks who are not outside or not exposed to heat for greater than 15 minutes are also not covered by this permanent rule that's been in place since 2008. Next slide, please. Again, in response to the Pacific Northwest heat wave last year, Washington State put in a enhanced temporary rule, is what they called it, in July. It expired in November, and they added prescriptive measures for extreme high heat, so over 100 degrees, and this is air temperature, not heat index. Again, water was required to be cool. There has to be shade areas while employees are present. You can use artificial body cooling methods to avoid this shade requirement, such as ice vests, cool towels, things like that. and then also ensure that employees take preventative cool down rest periods of 10 minutes every 2 hours, and those can be in line with and incorporate meal and rest breaks that are otherwise required by the law. Next slide, please. Now, what, other way. Thank you. So Washington has initiated permanent rulemaking. It is still going through stakeholder meetings, and we don't actually have official draft language yet, but there has been a telegraphing that Washington L&I will adopt another enhanced temporary rule to go into effect probably on June 1st. This is much more stringent and includes more requirements than the prior temporary rule from 2021. It includes a requirement for acclimatization. And if you go through the process, if you're away for 7 days, say on vacation, or you have a unique work schedule where you're away for 7 days, you have to go through acclimatization again. And then in addition, it has some of the similar things from what was included in the prior 2021 rule, including rest periods, which Washington pulled some of that idea from Oregon, and other preventative measures. We don't know when the permanent rule is going to be, draft is going to be issued, but likely soon, given that we're getting into the hot season again. All right, next slide. All right, now I'm getting back to federal OSHA. And before I do that, I'm going to read the CLE code for those of you who are on here for CLE. That is SS, as in Seyfarth Shaw, SS 8219. Again, SS 8219. All right, so turning back to federal OSHA, and this is all under the National Emphasis Program, as well as what we have seen in our cases dealing with the General Duty Clause. OSHA is going to come out on site, and I don't have this on this slide, but as part of the National Emphasis Program, they're going to take a look at documentation to see if there is a history of heat illness on the site. They're going to look at 300 logs. They're going to look at accident and injury reports. They're going to look at first aid logs. So that's the first thing they're going to look at, is they're going to say, okay, are we seeing heat illness on site? Then they're going to start talking to employees. I'm sure you're all familiar with OSHA inspections. They're going to want to talk to employees and say, hey, have you been told about heat? Have you experienced heat illness yourself? Do you know what the signs and symptoms are? Do you know what preventative measures there are? So those types of things are part of the National Emphasis Program, and they will be used when OSHA comes out on site to see if you are complying with the requirements of the General Duty Clause before this new OSHA regulation actually comes out. As part of a prevention program, the OSHA folks are going to talk about, they're going to look to see whether you have an acclimatization program. OSHA, federal OSHA, looks to see if you've been gone for 3 or more days. That is really important, because if you have a long weekend, Memorial Day weekend's coming up, that's 3 days. And then you come back and suddenly on Tuesday, you have to go through the entire acclimatization process again. That's a problem for a lot of employers, especially construction employers. Some companies have, you know, you're on for 5 days and you're off for 3, or you're on for 7 and you're off for 3, something like that. So that's an issue that OSHA needs to address if it's going to put this into a permanent rule. Again, you have to have work rest regimens, and based on the outdoor conditions, Fed OSHA is going to start looking at indoor work as well, and also metabolic heat. That's the heat that's generated internally from the work that you're doing. That gets added to the equation. They're going to look to see if you have guidelines or a written policy as to when you're going to take people out of the work site, and that's communicated to supervisors and those who need to know. If they're exhibiting certain signs and symptoms, like Mark was talking about, cramping, get them off the site, get them in a cooling van, that type of thing. Give them ice vests. They're going to take a look at that. They're going to look to see if you have climate controlled areas where the employee can recover before it gets to heat stroke. Now, if it gets to heat stroke, you're going to want to send them to the EMTs immediately. Excuse me. But they're going to look to see if you have a spot on site, even going beyond just having shade, maybe having some fans, or even air conditioning, like Mark talked about, the air conditioning van. Next slide, please. So again, training is a really key part of all of these programs, including the federal programs under the NEP and the General Duty Clause. Ensure that everybody at the work site, from the lowest employee to the highest manager, knows what the signs and symptoms are, knows how to prevent heat illness, knows how to prevent those things from taking place, and also knows what to do should somebody start showing these signs and symptoms. It's not just the managers or the supervisors who are important to making sure that employees stay safe. It's your coworkers. It's saying, hey, you know what, this guy over here, this gal over there, she looks like she's struggling. She looks like she's having some problems. Let's get her, have someone go and talk to her. One of the key things having to do with this Bermuda Triangle that Mark talked about is make sure that employees, especially supervisors, know what some of the restrictions are in terms of the questions that can be asked about why this person is experiencing heat illness. Do they have underlying conditions? Are they taking medications that might make them more susceptible? And as part of that training, advise employees that there should be a consultation with the doctor or their pharmacist to see if that could affect heat illness susceptibility. Finally, and this is again important, and I discussed this already, I know, tracking weather conditions at the job site. OSHA has and NIOSH have an app that you can look at to see what the heat index is and what associated risk level or tolerance level there's going to be, using temperature monitors, using various types of thermometers, and learning and knowing how to use them, because if you use them wrong, it is possible to come up with the wrong answer and you don't put in enough protections to protect your employees. Next slide. All right, and the last thing here, and I already talked about this, is determining metabolic heat and how that affects that's combined with the outdoor temperature to show how a person is susceptible to heat. When it comes down to it, only a industrial hygienist or a professional can really calculate metabolic heat, but there are tools out there to use to kind of get a general idea as to, okay, this task is going to be a lot more strenuous and produce more heat and make a person more susceptible to heat illness than some other lighter task. Again, there's feasibility, if you have a huge work site, if you're at a big warehouse, if you're at a big manufacturing facility, there are a lot of people that you're going to have to evaluate their jobs to determine what potential types of metabolic heat might be presented by those jobs. So that could be a big lift for certain employers. Again, you have to take into consideration the limitations on what you can ask employees and what information you can get related to pre-existing health conditions, medications, physical health characteristics, that type of thing. And then obviously there's, under the ADA and employee privacy laws, you can't actually, in certain circumstances, the employer has to be very careful about conducting company medical evaluations or examinations on a particular person without certain types of notice and that type of thing. So that's all I've got here. Next slide. And I think, Alana, it's back to you for the end of the program.
Yep, thanks, Patrick. So challenges that employers face when putting together a program in the federal OSHA sphere, because it's not a one-size-fits-all approach. It's most easier in states that have more prescriptive standards. You have a certain temperature and you have to do X and Y and Z. In federal OSHA, that's not the case. So key challenges, acclimatization. You have to determine when environmental conditions are going to require that. That means identifying particular jobs that are going to need it more than others. You have to consider staffing and making sure you have sufficient employees to perform work, because during the period of acclimatization, you're not necessarily going to have all employees working all the time. And then you have to look also at potential impacts on collective bargaining agreements. Same with work rest regimens. You have to determine when that is going to be required. You have to look at timeframes, and then again, making sure you have sufficient employees available to perform the work. So these are things that you have to think about beforehand. You don't want to be in a position of having to determine that, the day work begins at a site. Next slide. Removal of employees. This is a really tricky one. One of the keys to developing a program is establishing some objective criteria for signs and symptoms that will trigger removal. It can be really difficult to determine when an employee is experiencing a heat-related illness. It can also be really difficult to determine if the symptoms of heat illness are in fact due to exposure to heat. We have a case right now where an employee was displaying symptoms of heat illness and it was treated as that, and it turned out it was a underlying condition related to cardiovascular disease. So if it had been heat illness, the appropriate response was just self-care, hydration, but it turned out this employee actually needed to be transported immediately to a hospital, and unfortunately he passed away. So you have to be really attuned to employees and whether they might be experiencing heat illness. Set the bar low. When in doubt, you want to initiate emergency response procedures. And then also keep in mind that other conditions can have symptoms that look like heat illness. So when in doubt, again, you want to initiate emergency response and have the benefit of medical professionals weighing in. And I think next slide. And that concludes our webinar for today.
And I just have one thing I want to re-add on the heat illness prevention program and having inspections on site. I suggest that all of you go and take a look at the actual national emphasis program that's published on OSHA's website. You can skip through about 90% of it down to about the middle, last half of it, and it's going to have a list of questions that a compliance officer is told to ask when they come on site. And those questions are going to be key for preventing a general duty clause citation for heat-related issues. And if you can answer yes to most of them or all of them, that's going to go a long way to getting out of that inspection successfully and without any citations. So that's all I've got to add to that.